4, 3, 2, 1.
This Honorable Court of Appeals is now in session.
Good afternoon. I'm Judge Neil McBrayer, and on behalf of Judge Arnold Golden and Judge Karma McGee, I welcome you to this oral argument this afternoon. I'm going to handle the proceedings in much the same way as we would had we all been together in the courtroom. Hopefully that will not be in the too distant future. Mr. Kessler, I understand that you reserved 3 minutes for rebuttal, and that request is granted. If there's no preliminary matters, I'll ask the clerk to call the case, please.
Shannon, Giles et al. Versus Geico General Insurance Company.
Mr. Kessler, you have the floor.
May it please the court. My name is Nick Kessler. I'm a member of the Franklin County Bar. This is a Marion County case. I would say that probably in the trial court, Mr. Patton and I probably spent about an hour arguing this motion. As you can see, that our briefs are extensive, and I'm going to do the best I can within the few minutes that we do have. This appeal could be a simple appeal or a complex appeal, however you want to look at it. But to start with, the basis of the appeal is because the trial court said that the penalty, the bad faith penalty statute, did not apply to automobile insurance policies. And if we want to keep this appeal on a simple way, Mr. Patton has provided several Supreme Court cases. I've provided several Supreme Court cases. They both say different things. Some of the older ones that Mr. Patton provided, the People's Bank and Trust case, the Cherry case, and the Medley versus Cimarron cases, they're in direct contradiction to some of the cases, more recent cases that I've cited, the Wilhite versus Tennessee Farmers, the MFA versus Flint case, and the Gaston versus Tennessee Farmers case. And I've just tried to wrap my head around, what I didn't say in my brief, if there's anything there. I mean, I'm sure we both briefed it extensively, but it goes back to the People's Bank and Trust case. And in that case, the court looked at the applicability of the bad faith statute to a fidelity bond. And in that case, they said that the statute didn't fall within that kind of case because it was a bond. And the statute at that time didn't appear to address fidelity bonds. It appeared to be just insurance companies. And so then we get to the Tennessee Farmers versus Cherry, where they go back to the People's Bank case and they note that in that case, it does say that accident insurance policies, which is what we've got here, would be applicable to the bad faith statute. But then they run with this interest. They pick up on a small, in the Cherry case, they pick up on a small part of the statute that says and loss and interest thereon. And then they make an assumption that if the policy doesn't bear interest, then the statute does not apply to it. The case says that. It does say that, and I don't know how you get around it other than the statute changed. The current statute that we have now reads more than just it does address fidelity bonds, and where the Cherry court picked up on interest thereon, the current statute says in addition to the loss and interest on the bond, because the current statute applied to a bond. It doesn't appear in the current statute that they're limiting interest to the policy. It appears to be just the bond. The statute I'm looking at is effective August 14, 2008. And even though some of these cases that I have cited are before that, it's just clear. I think that the Supreme Court has changed the law on this, particularly the Wilhite case is a 1974 case. It doesn't say much other than in that case, the penalty was imposed on an uninsured motorist carrier. So not only are they imposing it on auto insurance policies, but uninsured motorist carriers as well. And the leading case that I've cited is the MFA versus Flint case. That's a 1978 Tennessee Supreme Court case, much later than the cases cited by defense counsel, the Tennessee Farmers and Cherry case. MFA versus Flint case goes through detailed the duty of good faith from an insurer to their insured when they're selling an uninsured motorist policy. If anything overrules what was previously said by Cherry and Cimarron, in the MFA case certainly does it. It clearly says an insurer is under a duty of dealing with its insured fairly and in good faith in settling a claim by its insured under the uninsured motorist provision of an automobile liability policy, automobile liability insurance contract. It goes on to detail about what that duty actually is. And so I would ask the court to say that yes, the subsequent court, the change in the statute and the later cases from the Supreme Court would certainly lead to the conclusion that the bad faith penalty statute applies to automobile insurance policies. You know, and at this point, the court could take those cases that Mr. Patton has cited, those cases that I've cited, and come up with something. We've cited, you know, different cases that say different things. I would say that the more recent cases are controlling, and that's why that the court should find that they apply to the statute. At that point, the argument could end. I mean, that's all the trial court said. The trial court didn't get into the pages and pages of facts that Mr. Patton and I got into in our briefs. But under abundance of caution, I could find myself in a position where this court could say, you know, Mr. Kessler, we'll agree with you. The bad faith statute does apply to automobile insurance policies. But if I didn't give you anything else, I could face maybe this court saying, well, Mr. Kessler, you didn't give us anything else. So that's when I go on with the remainder of the argument. It could stop with whether the statute applies to policies or not. And so as an abundance of caution, I have addressed the Reit factors. The Reit case lists out the 4 factors that would that make the bad faith statute apply to a particular case. The first of those factors is the policy of insurance in the instant case was due and payable. And that was one of our initial arguments when this case began, was whether it was due and payable or whether the plaintiffs were legally entitled to get paid in this particular case. We dealt with that in a motion to dismiss the complaint, which was denied by the judge, and then that interlocutory appeal to this court. This court didn't see it for an appeal. So, but neither in that case, the basis of whether due and payable is there was clear liability in the underlying lawsuit. We had a drunk driver that just rear-ended Ms. Giles. That was reported directly to Geico Insurance Company. Geico accepted liability within days, 100% liability within days of the actual crash taking place and the report being made. Other evidence of liability was that by the time we got to trial, there was never any defense put on whatsoever by the underlying Alpha, the underlying carrier, or Geico. There were no witnesses, nothing presented. So I would say that, and as far as
there was no challenge at all to your damage request then?
No, Your Honor, that was part of my argument that I'll get into later. They had an opportunity to get an independent peer review, medical review. They said at one time that they were going to do it, never did it. And so their decision to deny the medical part of it was just based on layman with no medical experience. And when on the other hand, all the medical records, the treatment Ms. Giles' treatment was completed pre-suit. And all the medical records and medical bills that were used at trial were the same medical records and bills that were in a pre-suit demand. Nothing ever changed. So all the way through the lawsuit, they had liability was clear, and whatever damages were there, they were there. They were done pre-suit. There was no more medical treatment after suit. It was all done from the initial demand. I think that was done in November of 2013. So whether it's due or payable, they had liability and they had all the damages before them. Not to mention that when we get into litigation, there's testimony from Ms. Giles in her deposition that she had permanent injury. She could no longer do her job. That was supported by the doctors. But quickly getting into the second element, a formal demand for payment was made by the plaintiffs. In my brief, I set out several letters that were demands that were made. And I think what it's looking at is in that case, was there a formal demand under the bad faith statute or threat of bad faith? And the specific letters that I pointed out in my brief, at least from April 20th, 2015, and another letter from December 28th, 2015, those explicitly alleged and threatened bad faith for Geico not paying the available policy limits. So I would say that number 2 is satisfied. Number 3, the plaintiffs waited more than 60 days after making the demand before filing suit. Well, those were demands made in April and October of 2015. This underlying bad faith lawsuit was not filed until September of 2016. At that point, I say that the 60 days had well passed from the bad faith threat or demand. And then the next part of the 4th factor of the Reit case is the refusal to pay was not in good faith. I've alleged, number 1, I put kind of 2 separate theories of bad faith, but neither way, before we even get into those, this is where it becomes the jury question. Was it in bad faith? Once we get past 1, whether was it due and payable, was a demand wait, did we wait more than 60 days? Was it in good faith? That is where this becomes a jury question. And I won't sit here and regurgitate all the facts in my brief about what they did to fail to investigate. I may have alluded to it already. They had all the pre-suit information about her medical expenses and treatment. They did all that information, again, when the discovery was closed, when the expert disclosures were made, when Dr. Brown, who was the treating physician, made his report. And all of this time, they just said we just didn't put any stock in the doctor's opinion. That's not an investigation. They said, we're going to get a third-party review done. They never did it. They probably had about 6 adjusters on this file from beginning to end who just dropped the ball is the basic way to put it. And when it came to trial, they had absolutely no defense to liability, no defense to the medical proof. All they had was an attorney's argument who was not even Geico's attorney, it was Alpha's attorney, to just argue, well, the attorney did all this. The attorney did all this. But there was no proof whatsoever put on by the defense at trial. And finally, just the awkward letter was just to get into it. I don't see how Geico's defense counsel told their adjuster, we've got a settlement, send me a check. And then 9 days later, they sent plaintiff's counsel a letter saying, well, we'll settle for $25,000. It was just so awkward, and it seemed as though they were just trying to get the plaintiffs to believe that $25,000 was limits, take it, and to deprive them of the balance of their policy, which would be another $50,000, $60,000. And for those reasons, I believe that this court should reverse the grant of summary judgment. If the court wants to go into the facts and actually make a decision on the summary judgment, or remand it back for the trial court to go into these facts and find out if summary judgment's appropriate or not. That's the balance of my time. Thank you.
Thank you, Mr. Kessler. Mr. Patton, we'll hear from you on behalf of the appellee.
Good afternoon, Benton Patton of the Nashville Bar for Geico General Insurance Company, the appellee. I, like Mr. Kessler, will rely upon my brief that has been submitted. There's a lot of issues in this case. The trial court picked the threshold issue to grant summary judgment on, and we're here today to ask the court to affirm that. But we likewise have addressed all issues raised in our motion for summary judgment, and will rely upon our brief and detailed discussion of all of those issues. But I will hit the high points in my oral argument today. If the court has any specific questions on the facts and circumstances of the underlying case, the facts and circumstances of this bad faith case filed in September of 2016, I would be happy to answer them. I'm going to start with where we are. This case is proceeding under Tennessee law only now. As the court noted from review of the plaintiff's brief, there's a lot of discussion of the Pontus case and the Lefevre case out of Alabama. When this case was originally filed, there were 2 causes of action against Geico: common law bad faith and the claimed statutory bad faith pursuant to Tennessee TCA 567105. When we answered the suit, we pled alternatively that Alabama law applied. This is an Alabama contract issued to Alabama residents on vehicles principally garaged in the state of Alabama. As a threshold matter, we argued that the rights, duties, and obligations of Geico to the insureds would be governed by Alabama law. And we made that argument in our motion to dismiss. The motion to dismiss was denied, but more importantly, this lawsuit's never been amended. Alabama law is not before this court. The only thing that is currently before this court is 567105, whether or not it applies to this type of policy and whether or not plaintiffs have proven the prongs applicable under 567105. And that's important because Alabama law recognizes common law bad faith, and they recognize common law bad faith against carriers. Tennessee does not. Tennessee has a statute. So Alabama law has nothing to do with what we're talking about today, respectfully. The threshold issue, as Mr. Kessler noted, is that the trial court found that 567105 does not apply to automobile insurance policies, and the court granted Geico summary judgment on that issue. And we can go through and talk about the cases, and they are briefed extensively in our brief and in the plaintiff's brief. But I will go through those briefly in this oral argument. Basically begins with the Tennessee Farmers Mutual versus Cherry case, a Supreme Court case decided in 1964, technically under the prior statute, which was 561105. 567105 did not come into existence, codified at that number until 1981. In the Cherry case, it was a case against an auto liability carrier for not paying a judgment. The trial court made the liability carrier pay the verdict on the judgment and the statutory bad faith penalty. The Tennessee Supreme Court looked at it and specifically said, no, TCA 561105 does not apply, and there's no statutory bad faith penalty on this policy. The Draper case, another Tennessee Supreme Court case in 1970, held that this statute is not applicable to policies of garage liability insurance. The Medley versus Cimarron case, another Supreme Court case decided in 1974, a very similar fact pattern to Cherry. A liability carrier did not pay a judgment. The trial court again granted the statutory bad faith penalty, and our Supreme Court again said no to that. We've also cited to the Hearst Company versus Bitmus Insurance Company case. That case was appealed on other grounds, but the court in that case, the appellate court, noted in a footnote that the trial court did award the bad faith penalty, but that issue was not raised on appeal. So I think it's clear from those cases what the Supreme Court has said on that issue. And it's fairly simple.
Isn't it less clear after Gaston against Tennessee Farmers?
Could be, Your Honor, and I'll address that. Well, I can go ahead and address that. The Gaston case, and the Gaston court even said in the opinion that this was a unique set of circumstances and facts. It was a refusal to pay case, which all of these cases can be distinguished from the case in front of the court today, because this is not a refusal to pay case. This is not a case where a carrier, Geico General Insurance Company is the carrier, refused to pay. But Gaston was a refusal to pay case. But the Gaston court, respectfully, Judge, did not even discuss Cherry. I don't know if Cherry was not brought up by counsel, but certainly the Gaston opinion, nowhere within its body does it ever specifically overrule Cherry. And
I wonder if Gaston in effect means that the statute can apply to auto liability insurance, but only in certain circumstances. Could we interpret Gaston in that manner?
Respectfully, Judge, I don't think you can. I don't, and the court will construe Gaston however it wants to construe it. But I think the reasoning behind the Cherry case and Cherry's progeny, that this statute is intended to apply to life insurance policies, fire insurance policies, where you have a date certain that the policy becomes due and payable, a life insurance policy upon death, a fire insurance policy upon the fire. This statute is not designed to address a situation where a disgruntled plaintiff insured wants to sue their own insurance company because they didn't offer them enough money to settle their case prior to trial. The Wilhite case was another failure to pay case from 1974. Again, the Wilhite court did not specifically address Cherry and did not specifically overrule Cherry. And plaintiff's reliance upon MFA Mutual versus Flint. MFA Mutual versus Flint, a 1978 Supreme Court case, does not even discuss the bad faith statute. In that case, the court ultimately did set aside a release, but it does not discuss the application of 561105, which was the statute that was in existence at the time. Respectfully submit that these cases do not overrule Cherry specifically, and they do not overrule Cherry by implication. Why are these cases like they are? as the court
It
noted in the
sounds like-
Bitmus.
It sounds like you're asking us to adopt sort of the same analysis as the federal district court did in For Senior Help against Winchester Fire Insurance Company. Is that?
It's not been briefed, Justice McGrayer, but you're exactly right. And I've reviewed it. I reviewed Judge Trauger's opinion. The case is deep, and it's much more than just 56-7-105.
Well, I mean, I guess what you would say is we should just copy footnote 7.
Yes. Well, yes, because Judge Trauger ultimately opines in her footnote, this court accordingly cannot conclude that Gaston overruled Cherry simply by implication, though the more recent opinion certainly calls into question the continuing validity of Cherry.
And then I would say, yes, Judge Trauger, it sure does. But you're telling me it does not.
I'm telling you it does not, and I'm telling you that I would request this court take the same position as Justice Trauger did in saying that Cherry is still binding law in the state of Tennessee from our Supreme Court and has never been overruled. The court might not agree with me on that, but that would be my position. I have some notes in here about why this happened, why there are cases that discuss the bad faith penalty statute in auto liability cases. Lawyers didn't bring it up. As noted in the Bitmus case, the lawyers evidently just didn't take issue with the court allowing the statutory bad faith penalty when the court clearly stated in the footnote that it did not apply to that type of policy. The bottom line is that the Cherry's never been overruled by the Supreme Court. If the Supreme Court wanted to do something with Cherry specifically, they would have done so. They could have done so. The legislature could have enacted statutory protections to a plaintiff in a situation like we have here, like the legislature did back in 1901 when they initiated the bad faith statute to begin with. Respectfully, this case, the appeal should end at this point, but like Mr. Kessler, and given the fact that he's briefed the remaining arguments that we had in our motion for summary judgment, I will do so as well. Assuming that this court finds that TCA 56-7-105 does apply to an automobile liability insurance policy, the Reit factors are 4. I'm going to address 1 and 4 of those factors, but we have addressed all of them in our brief. And the threshold issue before the court, if we get to this, did the policy of insurance by its terms become due and payable? When was the policy limit of this policy due and payable? Courts interpreting 56-7-105 determined that a policy must become due and payable before the statute's applicable. We basically gone back and looked at the Tennessee uninsured motorist statute 56-7-1201 to give this court, the trial court and this court, some guidance on when a policy becomes due and payable. 56-7-1201 tells us that before a plaintiff insured can recover from his own uninsured underinsured motorist carrier, plaintiff must prove that he or she is legally entitled to recover compensatory damages from the uninsured motorist. The Glover Supreme Court told us in 1971 that legally entitled to recover means a legal liability that the courts will enforce as between litigants.
Mr. Patton, was that in any way disputed that they were not entitled to recover under the UM?
At what point, Your Honor?
Well, I'll ask you that. At some point, you had to determine whether or not, apparently y'all were able to determine what the policy limits were on the underlying policy. So you knew whether or not your policy came into
exposed.
Correct.
It was exposed, Your Honor. And yes, there was a decision made early on that the Geico policy was exposed.
I mean, that seems like easiest links here is to determine that. I mean, no dispute about that, I guess is what my point is. I mean, what's to argue about that?
No, due and payable. When are the policy limits due and payable to the insured?
I know, but you're saying when did it, the first thing is we have to determine whether they even apply here. And I'm saying there's no dispute about that. So
no, there's no dispute that they had an underinsured motorist claim. Evidenced by the fact that Geico had made them a $22,500 offer pre-suit before the underlying suit was ever filed. Ultimately, at the end of the day, we had a dispute on the value of Ms. Giles' personal injury claim, a claim for unliquidated damages in tort. that you can't put your finger on and say, here's the exact number.
I guess one way to look at that would be, and I don't know whether there's been any discovery of this, but presumably your claims people make a determination as to what they think the value of a claim is.
Certainly.
So, I mean, presumably that potentially would be, if summary judgment's reversed, that would be information that would be perhaps available for the plaintiff to determine when did Geico determine what the value of this claim was and when it should have been paid.
I think it's fairly, not well, completely clearly, but it is set forth in the record. And I'll skip to the formal demand for payment. And that's not something I'm going to discuss in great detail, but since the court's brought it up, as the court is aware in the initial complaint, the triggering event, the demand for payment under 567105 is claimed to have been the October 29th, 2015 offer of judgment that was submitted only to Mandy Harris, did not name Geico, and did not reference 567105. And not 2 months later, Your Honor, the case was mediated. And at the mediation of the case with Judge Perry, the parties actually got within $20,000 of settling this case. That's Alpha's money, the $25,000 in underlying liability coverage, $35,000 from Geico as UM money, plus the $10,000 in medical payments that are available under the policy that were paid by Geico even prior to suit being initiated. And at that point, the plaintiff's demand to Geico was $65,000. So at that point, in late December of 2015, there was a genuine dispute on the value of Shannon Giles' personal injury claim, and the parties actually got to within $20,000 of being able to settle the case at that point in time. That's proof of not only Geico did not refuse to pay the loss, but there was also a genuine dispute as to the value of the case at that point. And what did Geico know at that point in December of 2015, 3.5 years after the underlying suit was filed and 4 months before the case was set for trial? They knew it was a case of liability against the defendant. They knew Ms. Giles had sustained a soft tissue injury. She didn't have any surgery. She didn't have any broken bones. They knew that Shannon Giles' treatment had been completely orchestrated by her attorneys in Alabama. They paid the $10,000 in med pay directly to the attorney for $10,000 in chiropractic treatment and $35,000 in rehabilitation and neurological services. She had no impairment rating at that point. She had no documentation of lost wages, and her last medical treatment was 3 years prior, September of 2013. Dr. Brown was not even a blip on the screen at that point. Dr. Brown got involved in this case 3 months before trial to opine reasonableness and necessity and impairment rating. Geico didn't know any of those things at that point. And for plaintiff's counsel to make the argument that Geico didn't try a good enough case, didn't fight the case well enough, that's not what 567105 is about. Johnson versus Tennessee Farmers is not applicable to this case. That's a case where an insured got hit for a judgment. In that case, the insurance company was found to have acted in bad faith because they did not satisfy their duty to defend. Geico had no duty to defend Ms. Giles in this case. Geico was defending an uninsured motorist claim. And if I might just briefly address the March 15th offer that Mr. Kessler now brings up as another evidence of bad faith, this case changed hands numerous times at Geico. Tennessee lawsuit, Alabama policy. At that point in time, a new adjuster got involved, saw that the policy limits on the policy were only 25, thought that would settle the case, did not look deeper to understand that this was actually an Alabama policy at issue. Alabama allows stacking, therefore the actual coverage was 75. There was no harm to Ms. Giles because that offer was made.
Thank
It was
you,
a
Mr.
mistake.
Patton. We briefly addressed that extra issue.
Thank you for letting me get that in, Justice. Thank you.
Mr. Kessler, we'll hear from you on a rebuttal.
As far as Mr. Patton, he mentioned something about Alabama law. There are some Alabama law cases, but we are not saying that Alabama law applies. The Pontius and Lefebvre case that were raised in the brief were actually raised by Geico in their motion to dismiss because there were no Tennessee cases that were instructive on what legally entitled meant. So we're asking for Tennessee law to apply. And as far as what the uninsured motorist statute does say, is liability fixed? We had liability that was fixed quickly. And then can the plaintiff prove their damages? Well, the plaintiff's damages, the medical bills and so forth, never changed from pre-suit to trial. As far as Geico's evaluation, that they say we have a dispute as the value of the claim. Well, I think a jury verdict of $300,000 plus is a pretty good indication of what the value of the claim is if we rely on our jury system. Unfortunately, in this case, there was only a total of $110,000 policy limits. With the $50,000 plus medical bills, the permanent impairment that she had, even though Mr. Patton points out that Dr. Brown didn't officially give a permanent impairment until later in the case. But there was testimony from Ms. Giles' deposition that's cited in the brief, where Attorney Taylor Forrester for Geico actually took her deposition. In his memo, he says she can't do her job anymore. She appears to be credible. So even from the plaintiff's deposition early into the case, they knew that there was proof of permanent injury. And Geico made absolutely no evaluation of her permanent injury. And that was the greatest part of the jury verdict award of the $100,000. They have their claim IQ computer system where they put in all their numbers. They put 0 for permanent injury, even without Dr. Brown, there was evidence of her permanent injury from her medical records, from her testimony. Even without Dr. Brown, they should have considered that. They should have, if they were going to dispute medical bills, they should have gotten a third-party peer review. They didn't do it. And they admitted in their deposition that Geico just dropped the ball on that one. Just dropped the ball. Maybe if they'd come to court with a doctor that said, Dr. Brown, you're wrong. This isn't related. This is something different. Maybe they would have something to stand on. But to say they have a dispute as the value of the claim without even making any effort to determine what that value was, or without even using the tools like a medical peer review and so forth, to dispute that. They did nothing. And that's where it becomes not an investigation, but rather it's bad faith in this case. And it should be a jury question. Those should be jury questions to go to the jury at a trial.
Thank you, Mr. Kessler. Are there any questions from the panel for Mr. Kessler? All right. Thank you both very much for your arguments. It's an interesting question. The case is submitted. Ms. Lindsay, will you recess court, please?
This Honorable Court of Appeals is recessed until 2 p.m.
All right. Thank you both. You can disconnect from the Zoom call.
Thank you.